Hello, everybody. It is time for the Crime Talk Weekly Recap. But you say to yourself, how could Crime Talk have a weekly recap when they've been in YouTube prison all week? Well, we also put it up on other platforms, and now we're bringing it here to you. The highlights of all the top stories throughout the week, conveniently located in one location. That's right. You're welcome. Hope you enjoy. All right, before we get to the docket, we are glad to be back. If you didn't notice, we weren't around for a week. Why? We were put in YouTube prison. For what, you might ask? Well, good question. I'm not sure if YouTube's algorithm did it or if we had a hater, but we put up a video and we talked about the 7-Eleven clerk that was assaulting the man that had come in 3 times in the same day to steal stuff, and they just simply had enough. Somebody said that was hateful, and they complained to YouTube, and they shut us down. So if it was a hater, hey, you don't need to watch our program. The truth can be a very enlightening thing indeed. But now, I'm sure, that's right.
Laugh now, because you clowns have been on double secret probation since the beginning of this semester.
That's right, Crime Talk. You have now been placed on double super secret probation by YouTube. But guess what? Doesn't mean we're going to stop bringing you the news. Thanks for watching. It is Brian Kohberger. So let's open the record. First, Brian Kohberger, the man accused of murdering 4 University of Idaho students in November. Well, he said he was going for a drive on the night of the killings, according to his attorneys and their filings as it relates to their notice of alibi. Now, this filing by the defense is the first time Kohberger has explained his whereabouts the night of the fatal stabbing. Now, Kohberger, for those who don't know, has been charged with the first-degree murder of the University of Idaho seniors Madison Mogen and Kaylee Gonsalves, Zaina Kernodle, and Ethan Chapin at an off-campus home on King Road in Moscow, Idaho. Now, Mr. Kohberger has had a habit, according to his attorneys, a habit that's key in the legal term. So they will try to present some other evidence that he does this on a routine basis of going for drives alone. Often he would go for drives at night, according to his attorneys. And the defense said that Kohberger was on one of these habitual drives late November 12th and into the early morning hours of November 13th, coincidentally the same night and date as the time of the alleged killings. Now, the defense said that Kohberger is not claiming to be at a specific location at a specific time and noted that he doesn't have a specific witness to say precisely where Mr. Kohberger was at each and every moment during this time period. Now, the defense called this motion simply an attempt to force the defense to open its work product files and let the state peek inside, and said the state was trying to push Kohberger into waiving his right to speedy trial. Now, as you may recall, Mr. Kohberger previously declined to provide a pretrial alibi in response to the state's demand. Defendant exercised his right to remain silent on the issue and stated that he could possibly testify on his own behalf at trial. Now, corroborating evidence showing Kohberger was not at the student's home that day may come in later in the form of cross-examination of the state's witnesses, as well as possible expert witnesses who may testify, according to the defense. We'll have to wait and see. What does this really mean? Well, under Idaho law, the defense has to produce a notice of alibi within 10 days. The defense has basically been able to string this out a little bit longer than normal because of the large discovery in the case. Normally, and in most jurisdictions where I have practiced, an alibi isn't due until 35 days before trial. And it's only if you intend to call a witness to testify as to where the defendant was. I don't think, frankly, that you need to turn over an alibi if you, the defendant, is going to testify to that in court. But hey, Idaho is a little different on lots of things, as we've learned from the Lori Vallow case and now this case as well. So at least he admits he's not at home, and now we're going to see if cell phone data is going to show exactly where he might have been. I think there's going to be a little bit of gap in time kind of exactly about the time the murders took place. We'll have to wait and see. Next, the father who is accused of murdering his missing daughter was sentenced in a separate case involving stolen guns. Remember Adam Montgomery, whose daughter Harmony Montgomery disappeared in 2019 and has since been declared deceased? Well, he will spend the next 15 to 30 years behind bars for each of the 2 armed career criminal counts, and they're to be served consecutive to one another, means one after another, according to the judge in his case. He will also serve 7.5 years to 15 years each on 2 counts of stealing the guns, with 5 years suspended on each count under a condition of good behavior. Now, those sentences would be served concurrently, but consecutive to the armed career criminal charges. Now, Mr. Montgomery is also facing charges for the murder of his young daughter. Jury selection in that case will begin on November 20th. So, Mr. Montgomery made a statement at his sentencing. Usually not good if you intend to appeal. So he said, quote, "So I understand that I was found guilty by the jury. I'm not here to dispute that at all. The only consideration that I ask of you this morning, Your Honor, is for you not to consider anything as it relates to the case regarding my daughter, Harmony. You probably won't believe me when I tell you this, but I didn't wake up in the morning and choose to become an addict." Apparently shifting gears a little bit. And then he said, "I will spend my time in prison utilizing it to be the best of my ability to change things about my life." He said he could have had a meaningful life, and he blew that opportunity through drugs. He then said, "I love my daughter unconditionally, and I did not kill her. Please don't consider anything that relates to those charges. Only consider the facts of this case." And guess what? The judge said, "Oh, I'm not going to consider that you're accused of killing your daughter and not helping the police in any way find her and locate her. No, I'm not going to consider that." So the judge said, "Guess what? That's all good. I'm not going to consider the murder charges. We're only here on the gun and armed career criminal charges for which you were found guilty. And guess what? Those are pretty egregious given your prior history of violence." The court noted that there are a significant number of aggravating factors in Mr. Montgomery's case. She cited significant violent behavior involving other weapons that Mr. Montgomery used to commit crimes, and some of his previous crimes that made him an armed career criminal was a home invasion where he held the homeowners at gunpoint and threatened to harm them. He also had an aggravated robbery charge. Yes, he is an armed career criminal. So the judge made it clear she wasn't sentencing him for those other crimes for which he is still given the presumption of innocence, but she whacked him really good for this particular case. Karma? That's just the way some things work out sometimes. Rex Heuermann says, "You're not getting my DNA." Serial killer suspect Rex Heuermann has refused to give his DNA in a swab as his lawyers are trying to raise doubt on the pizza crust used to link him to one of the 3 murders for which he stands accused of committing. Now, Mr. Heuermann has pled not guilty to first-degree and second-degree murder. He's also considered a prime suspect in the killing of Maureen Brainerd Barnes, whose remains were also located in the Gilgo Beach area. Now, Heuermann was linked to one of the murders through a mitochondrial DNA profile from a pizza crust and used napkin that was discarded from his Midtown Manhattan office. Now, Heuermann's legal team is battling a request from the prosecutors to gain a cheek swab for the DNA testing, commonly referred to as a buccal swab. So Heuermann's attorney, has argued that the Suffolk County District Attorney's Office is a far cry from the legal benchmark needed to force the architect to give up the swab. Now, prosecutors have filed a motion to obtain the cheek swab from Heuermann, and the state prosecutors are seeking further DNA testing to continue adding weight to their case that they already believe is quite strong against Mr. Heuermann. Now, the district attorney asked the court last week to sign off on the cheek swab because the pizza crust and napkin can only be referred to as purported to be touched by or used by Heuermann, according to the prosecutor's filings. So the prosecutor noted in their filings that, hey, Heuermann's DNA from the swab, if it doesn't match the DNA to the napkin and the pizza crust, the defense has a great potential case. But obviously the defense is saying, well, you don't have a case based upon that, and you shouldn't be allowed to go get DNA based upon the evidence that you have thus far. So the prosecution's argument, there is a clear indication that the material and relevant evidence will be found, and that will be crucial at trial. In the filings on behalf of Heuermann, his attorneys basically said that they are essentially concede they don't have any evidence to prove Heuermann actually ever came in contact with the pizza crust or this used discarded napkin. They put in their filings, thus, by the people's own admission, the nexus between the partially eaten pizza crust and the used napkin and the defendant Rex Heuermann is at best a matter of conjecture and assumption, not even rising to the level of fact. Now, normally obtaining a DNA sample is somewhat quite perfunctory these days, and the courts usually rubber stamp them. I believe the court will actually order Heuermann to produce the DNA buccal swab sample. But the prosecution may have jumped the gun a little early according to their own filings. As you may recall, when this came out, they said there was a match. This was it. This is the most believable thing you could ever find. And well, like oftentimes when they use this genetic DNA type of process or sample taken from the trash, they have to get a new sample. Normally it's quite simple, but this case, the defense is putting up a fight. We'll have to wait and see what the judge rules, and we'll bring you that news when it happens. There is some good lawyering going on in the Brian Kohberger matter, and I mean from the defense attorneys. Let me explain. So the lawyers for Brian Kohberger have put forward a statement by a genealogist that is trying to cast doubt on the reliability of the genetic genealogy, which investigators used to track down and identify Brian Kohberger as the suspect in the quadruple homicide there in Moscow, Idaho. Now, the detectives relied upon genetic genealogy to build their case against the Mr. Kohberger, as they used the method to build a DNA profile from the DNA left on a knife sheath at the scene, and then match that to a profile to Brian Kohberger's father just days before his arrest. Now, while prosecutors claim they matched the DNA from the knife sheath directly to Mr. Kohberger after he was arrested, they first used genetic genealogy, and his defense so far has focused on scrutinizing the process used by the investigators to collect evidence and build the DNA profile, arguing it could have been flawed and is ultimately unconstitutional. So in their most recent motion, they request the data and methods used by investigators to match the DNA evidence to Brian Kohberger. And in her affidavit, which I've reviewed, it goes for several pages. It's actually quite interesting, but I'm going to give you the highlight points from it here. Anyway, Dr. Larkin argues that DNA profiles built by at-home test companies such as 23andMe and Ancestry DNA are not constructed the same way as those by specialized laboratories and are therefore not reliable. Dr. Larkin notes that the sites such as Ancestry DNA, 23andMe, and MyHeritage prohibit forensic investigative genetic genealogy in their databases, but there isn't really a way to enforce that rule. So in the absence of an effective oversight, forensic genetic genealogists are on an honor system to obey the terms of service and the Department of Justice interim policy on forensic genetic genealogy. Dr. Larkin explains that the science used by these sites is not perfect, and any given amount of a centimorgan, that's an amount of DNA, can represent more than one possible relationship. She notes one example that has nearly 20 possible relationship lines listed for a match and says that's considered a close match. Larkin points out that the genetic genealogy testing identifies possible relatives, unlike DNA tests that find an individual, which are standard forensic STR tests. The doctor also notes cases where she's allegedly become aware of where genetic genealogy has been wrong and where authorities misused the databases. Now, the FBI, as you recall, tracked down Kohberger by tracing his distant relatives through genetic genealogy databases, secretly collecting a sample of his father's DNA to confirm his identity. Police say the DNA found on the knife sheath left at the Idaho murder scene is a statistical match to a cheek swab taken from the suspect after the arrest. Now, a sample of the DNA left on the sheath is at least 5.37 octillion more times likely to be seen if the defendant is the source than any other individual randomly selected from the general population. Now, Mr. Kohberger has no prior criminal history, meaning his DNA was not in any law enforcement database. That's why they turned to genetic genealogy. And genetic genealogy is an increasingly popular and useful method of investigation where law enforcement trace suspects' relatives on ancestry websites. And so when the DNA is found at the scene of the crime, that does not belong to the victims. The first thing the police do is run it through their own database to check if it matches any DNA of a previous offender. This process is referred to as a short tandem repeat, STR, comparison, and tests the sample against 20 DNA markers, enough to identify the person if their own DNA is already in the system, or in some cases, if the DNA of an immediate relative is in the system, for example, like a parent or a brother or sister. If both strike out, investigators have to look to genetic genealogy to perform a wider search for more distant relatives. Unlike police DNA databases, those of commercial genealogy companies can search for up to 1 million DNA markers using a single nucleotide polymorphism, which is not an STR, creating a much wider pool of relatives to sift through. Now, while many commercial ancestry websites exist, only 2 allow law enforcement to search their databases openly: GED Match and Family Tree DNA. Now, once the suspect is narrowed down, genealogical investigators turn their findings over to the police. Undercover or covert teams then follow the suspect and surreptitiously obtain a sample from them to compare it to the sample found at the crime scene used in the DNA tracing. As you may already know, Kohberger is accused of stabbing to death students Ethan Chapin, Madison Mogan, Zaina Kernodle, and Kaylee Gonsalves back on November 13th of 2022. And the detectives found the K-bar knife sheath on the bed with the bodies of Mogan and Gonsalves. The sheath was partially under Mogan's body and the comforter on the bed, according to the affidavit that we've seen. Now, investigators later matched the DNA on the sheath to the DNA found in a trash taken from Kohberger's parents back in Pennsylvania when he was arrested in December of 2022. So what this really means is, ladies and gentlemen, is the defense has a bad fact on their side. That bad fact is Brian Kohberger's DNA on the K-bar knife sheath. Any good defense attorney is going to say, all right, what piece of evidence do we need to disappear to make us have a defendable case? Clearly, it's the DNA. The prosecution has been asked, and they have rejected to turn over anything as related to their genealogical collection, analysis, survey, whatever you want to call it. And they're saying, we don't have that anymore. You're not entitled to it, etc. And up to this point, the defense really hasn't made a showing to the court that the information should have to be turned over. The prosecution has basically said, well, we arrested him, and then we got a DNA swab by court order, and we're going to go back and double check that. And if that's his DNA, good to go. If it's not, it's good for Brian Kohberger. More than likely it is going to come back and be a match. But the defense is saying, hey, we're entitled to this information because we believe that it was obtained basically unconstitutionally because, well, there was government action. Were they searching somewhere where they could find his DNA? It's going to get interesting. Like I said, the defense hadn't made a showing. However, the affidavit by the expert, Dr. Larkin, I think forces the court to have a hearing on this, and they'll have the doctor testify, and then somebody's going to have to come from the prosecution as a witness and testify as to what they did. May just ultimately get turned over. This is good lawyering. They have turned a basically non-issue into an issue that if there is a conviction, it is an issue preserved for appeal.
As a pet owner, you want to give your furry friend the very best. That's why Baked in Colorado's CBD-infused dog treats are the perfect choice. These delicious treats not only taste great, but they also provide a wide range of health benefits for your pet. CBD has been shown to have many positive effects on dogs, including reducing anxiety, alleviating pain and inflammation, and improving overall wellness. Baked in Colorado's treats are infused with premium, full-spectrum CBD oil, meaning your pet will benefit from the whole plant extract. Not only that, but Baked in Colorado's treats are made with all-natural human-grade ingredients, so you can feel good about what you're giving your pet. They're also free from wheat, corn, and soy, making them a great option for dogs with food sensitivities. Baked in Colorado CBD-infused dog treats are the perfect way to support your pet's health and well-being. With various flavors, including peanut butter, pumpkin, and bacon, your dog will love them too. So why wait? Head to www.bakedincolorado.com today and order your dog a bag of these delicious and nutritious treats. Your pet will thank you for it.
Let's go ahead and open the record and begin the docket for August 11th, 2023. Yes, that's right. Lori Vallow is going to take a little trip, and it's not through a portal. The Maricopa County Attorney's Office has officially taken steps to extradite Lori Vallow to Arizona. That's right. Lori Vallow, who used to live in the Arizona Valley there, was sentenced, obviously, to 3 consecutive life sentences in Idaho last month for murdering her kids, Tylee and JJ, and conspiring to kill her husband's first wife, Tammy Daybell. Well, guess what? She's now facing 2 more conspiracy charges in Arizona for the death of her former husband, Charles Vallow, and shooting at another relative who survived. Now, the Maricopa County attorney said that they have finished the paperwork in her office and plan to send it to Governor Katie Hobbs next week so that they anticipate Lori Vallow will be in Arizona by the end of the year. So the governor has to sign the governor's warrant and request that a warrant be issued. That will then be communicated to the governor in Idaho and the court system. And then Ms. Vallow can decide whether she wants to agree to the extradition or whether she's going to fight the extradition. We'll just have to wait and see what happens. Now, since Lori Vallow is in touch with everything and everybody, I'm sure she'll want to just go to Arizona as quickly as possible and get these matters resolved and let the truth come out. Now, as you may recall, Lori Vallow's husband, Chad Daybell, well, he's still facing a separate murder trial in Idaho that isn't going to begin until April of next year, basically facing the exact same charges that Lori Vallow faced and was convicted of there in Idaho. Now, Chad Daybell is not facing any charges in Arizona. We can't wait